The Subcommittee on Energy and Minerals Resources will come to order. Without objection, the chair is authorized to declare recess of the subcommittee at any time. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chairman and the ranking minority member. I ask unanimous consent that the gentlewoman from Wyoming, Ms. Hageman, be allowed to participate in today's hearing. Without objection, so ordered. I now recognize myself for an opening statement. Today, we will discuss the programs that manage two important aspects of coal mining in the United States: the regulation of active coal mining and the cleanup of coal sites abandoned before modern environmental protections, known as abandoned mine lands, or AML. These activities are subject to the same federal statute, the Surface Mining Control and Reclamation Act of 1977, or SMCRA. SMCRA is administered by the Office of Surface Mining Reclamation and Enforcement, or OSMRE, at the Department of the Interior. The AML, and active mining programs have functioned well for decades, but unfortunately, recent years have seen a major increase in delays for needed mine approvals. The creation of overly burdensome administrative guidance and new federal requirements outside of SMCRA that have made it harder and harder for states and tribes to develop their resources and clean up AML. Since the passage of SMCRA, AML cleanup has been funded by a fee on each ton of coal produced. These funds are then distributed to the states and tribes as grants, many of which run their own AML programs. This funding source was recently augmented by the Infrastructure Investment and Jobs Act, which reduced the fee by 20% and added an additional $11.3 billion in taxpayer funds to go towards AML cleanup. The new influx of funding could do a lot of good in assisting AML work, but unfortunately, many states across the country have struggled with new so-called recommendations, end quote, which OSMRE has added on top of his existing requirements in statute. States have also been given new administrative tasks in order to apply for IIJA funding, making them spend more time and resources on paperwork instead of filling the hole in the ground. When it comes to active mining projects coast to coast are facing delays in the approval process. New federal coal leasing is unfortunately under moratorium. However, even projects exempt from the leasing ban have run into major delays. Some of these approvals, such as mine plan amendment to expand production at a site in Wyoming, have already gone through multiple rounds of NEPA, but continue to languish somewhere at the top levels of OSMRE and the Department of the Interior. At the core of both the AML and active mining programs is the idea of state primacy. Under primacy, a state or tribe has been granted delegated authority from OSMRE to run their own programs. This long-standing authority under SMCRA is only granted to states and tribes with regulations at least as stringent as federal standards. This authority was created in 1977, very deliberately, recognizing that states and tribes have both the technical expertise and local knowledge necessary to find, prioritize, and select AML projects for cleanup, as well as manage other aspects of coal production specific to that state's geology. Any attempts by OSMRE to supersede that authority, such as their proposed dam safety rule and 10-day notice rule, would not only be unwise, but would go against one of the most important tenets of the coal program's defining statute. I look forward to hearing from our witnesses today about their experiences so that we can move towards a more transparent and efficient running of these programs. I am now going to yield to my colleague, Ranking Member Ocasio-Cortez, for her opening statement.
Thank you, Mr. Chair. And thank you to our witnesses for coming here today. Coal workers take well-deserved pride in building a prosperous United States economy and the American middle class. A century ago, coal workers fought and died to win workplace protections like the weekend that we now see as commonplace. And every American has a debt to coal workers for that fight. These workers won well-paid union jobs that provided good work for generations of families. But for around 15 years now, coal mining itself has been on a steep decline. In fact, no new coal plants have come online in almost 10 years, and nearly a third of operating coal plants are slated to close by 2030. Several factors are at play. Competition from natural gas and the rise of low-cost renewable energy has led to the closure of hundreds of coal mines. When coal plants retire, they're more often replaced by new renewable energy and not a new coal plant. And while the coal industry once helped communities across the country prosper, it also contributed to devastating health, environmental, climate, and long-term economic impacts. The black lung epidemic has ravaged miners. An estimated 1 in 5 tenured miners in central Appalachia has black lung disease, a devastating and potentially fatal illness caused by inhaling dust underground. Meanwhile, cancer occurs at significantly higher rates in communities with mountaintop removal mining. Water pollution from abandoned coal mines has devastated thousands of miles of streams and rivers. Unreclaimed mountains of waste rock create looming threats of landslides for homes downhill. Carbon emissions from burning coal are responsible for about 40% of global emissions from fossil fuels, a significant contribution to the climate crisis that simply cannot be ignored. And due to coal's decline, over the last 10 years, more than 60 coal companies have gone bankrupt, including companies that were once some of the largest and most prosperous. When coal companies file for bankruptcy, they too often spin off their unproductive mines, and this is what we should be focusing on and talking about today. They drop their obligations to clean up old mines, and they stop paying health care and pension obligations to the communities and the very workers who gave up so much of their lives in service to these companies. In doing so, these companies break their promise to neighboring communities and everyday Americans who expected clean water and air, and to the workers who risked their well-being and expected these benefits for the rest of their lives. They were promised them. In 2017, seeing this crisis unfold, Congress and this committee stepped in to guarantee health care benefits for more than 22,000 retirees and widows when coal companies left them behind. In 2019, we again stepped in to protect mine workers' pension benefits for 100,000 more. In doing so, we worked closely with the United Mine Workers of America and made sure that no worker was left behind. I'm proud of the work that we've done with UMWA to protect these essential services. But to be clear, it was the public, not the coal companies, who picked up the tab for the coal industry's failures. The public. And now the remaining coal companies, which are all at risk of bankruptcy in a dying industry, may try to forfeit their environmental reclamation liabilities and the promises they made to workers as well. So let us be clear. This problem is not inevitable. It's not that these companies simply cannot afford to pay for reclamation. It's that they are choosing not to. Through bankruptcy, these companies are consolidating mines with little recoverable coal to smaller companies, many of which will also or may also go bankrupt in order to avoid the responsibility of cleanup, responsibility that they have not just to the American people, but to this entire country. Meanwhile, reclamation bonds for cleaning up these mines are consolidated to newer and riskier insurance companies. It's not right, it's not fair, and it's a matter of environmental and economic justice. And the solution to this unfolding crisis is not to provide false hope that coal will return. We need to face this fight head on and make sure that we're holding coal companies accountable, that we're taking care of workers and their communities while we still can. And with that, I yield back to the chair.
Thank you very much. Normally at this point, I allow the chair of the full committee and the ranker of the full committee their opening statements, but I don't see them here, so we're going to go right into opening statements. Let me remind the witnesses that under committee rules, they must limit their oral statements to 5 minutes, but their entire statement will appear on the hearing record. To begin your testimony, please press talk button on the microphone. We use timing lights. When you begin, the light will turn green. When you have 1 minute remaining, the light will turn yellow. And at the end of the 5 minutes, the light will turn red. And I will ask you to please complete your statement. I will also allow all witnesses to testify before member questioning. And before I introduce Ms. Owens, I will say that votes are expected to be called any time. So there will be, we will stop so we can vote and come back as soon as practical and start. So Our first witness is Ms. Glenda Owens, and she is the Deputy Director for the Office of Surface Mining, Reclamation, and Enforcement, located right here in Washington, D.C. Ms. Owens, you are now recognized for 5 minutes.
Good morning, and thank you, Chairman Stauber, Ranking Member Ocasio-Cortez, and other members of the subcommittee. Thank you for the invitation to testify on behalf of the Office of Surface Mining, Reclamation, and Enforcement. Through the Surface Mining Control and Reclamation Act of 1977, Congress established OSMRE for two primary purposes. First, to ensure that the nation's coal mines operate in a manner that protects citizens and the environment during mining, and to restore the land affected to a condition capable of supporting the uses it could before any mining, or to higher or better uses. Second, to implement the Abandoned Mine Land Program and address the hazards and environmental degradation resulting from 2 centuries of coal mining activities before the law was passed. OSMRE's Title V programs provide resources to 23 primacy states to administer their regulatory programs on state and private lands. These programs protect the public and the environment from the adverse effects of current mining and support the reclamation of impacted lands after active mining operations have concluded. OSMRE provides oversight of state regulatory programs and directly implements SMCRA on Indian lands and in states that do not have primacy. The Title IV programs provide grants to states and tribes to conduct reclamation on sites mined before the enactment of SMCRA. OSMRE evaluates state and tribal AML programs and ensures reclamation of mining-related hazards while promoting partnerships to address water quality issues. OSMRE also administers the Federal Reclamation Program, including watershed cooperative agreements, civil penalty projects, and emergency projects. Since the establishment of the Abandoned Mine Land Economic Revitalization Program, Congress has authorized through annual appropriations $912.5 million in total AMLR funding, with the purpose of reclaiming abandoned mine lands in conjunction with economic and community development opportunities. The AMLR program has provided funding to the 6 eligible Appalachian states, as well as the Crow, the Hopi, and the Navajo Nation. OSMRE verifies and assists with project eligibility determinations on the submitted AMLR grant applications, and since FY 2016 has received over 290 project applications. Of those project applications, 284 have received preliminary approval. Nearly 180 have received authorizations to proceed, and almost 70 are complete. The bipartisan infrastructure law provided a once-in-a-generation investment in revitalizing the economy and environment of America's coal-field communities. In addition to extending the AML fee collection authority under SMCRA, the infrastructure law authorized and appropriated $11.293 billion for a deposit into the Abandoned Mine Reclamation Fund, with approximately $10.8 billion to be distributed to eligible states and tribes on an equal annual basis, approximately $725 million a year over a 15-year period to help restore impacted coalfield communities. So far, OSMRE has provided $721 million in FY 22 bill grant funding to the 22 eligible states and the Navajo Nation, and awarded more than $21 million in FY 2023 grants to 5 states, with 7 additional state grant applications currently pending. OSMRE is ensuring that current coal mining is conducted in a manner that protects the public and the environment, and that formerly mined lands are reclaimed to productive, safe, and beneficial uses. OSMRE will continue to work closely in partnership with our state and tribal partners and stakeholders to achieve these goals. Thank you again for the opportunity to provide this testimony and to appear before you today.
Thanks for your testimony, Ms. Owens. Our next witness is Mr. Benjamin McCammett. He is Chief for the Division of Mineral Resources Management, Ohio Department of Natural Resources, located in Columbus, Ohio. Mr. McCammett, you are now recognized for 5 minutes.
Good morning, Chairman Stauber, Ranking Member Ocasio-Cortez, and members of the subcommittee. I am honored to appear before you today. My name is Benny McCammett, and I serve as the Chief of the Ohio Department of Natural Resources Division of Mineral Resources Management. My division includes both Ohio's Abandoned Mine Lands Program and the Coal Regulatory Program under the Surface Mining Control and Reclamation Act. I am also the immediate past president of the National Association of Abandoned Mine Land Programs. The state of Ohio appreciates Congress's continuing support for the state's SMCRA programs, especially the investment in the AML program. My testimony today will highlight the successes of Ohio's SMCRA programs as well as the challenges that we face. The funding Congress provided via the IIJA has enhanced coal AML work in Ohio. In addition, the STREAM Act, which Governor DeWine supported, was a very helpful clarification to the IIJA, ensuring that we can focus adequate funding and attention on restoring water resources that were impaired by historic coal mining. Ohio has operated the SMCRA program successfully for over 40 years. With the nearly $700 million over 15 years we will receive via the IIJA is a 4- to 5-fold increase in historic funding levels. This comes with much responsibility to ensure the funding is used for eliminating as many as safety and environmental hazards as efficiently as possible, both for states and for the Office of Surface Mining Reclamation Enforcement. I would now like to highlight some challenges caused by the new administrative processes and decisions at OSMRE that could be problematic. Regarding the Abandoned Mine Land Program, OSMRE has determined that all mandatory annual grants must be applied for, tracked, and reported on separately. States have a long history of having adequate financial controls in place and have asked OSMRE to combine and simplify IIJA and fee-based AML grants at a minimum, allowing states to spend less time on administrative tracking and reporting for multiple grants that cover essentially the same activities. OSMRE is also requiring an update of approved reclamation plans. This update should be a lower priority than ramping up reclamation work, especially considering Ohio has a reclamation plan update that has been pending for over 5 years. Lastly, the continued funding support for the Abandoned Mine Land Economic Revitalization Program, AMLR, is greatly appreciated, and the outcomes of creating new job opportunities through this program are needed in Ohio. Even with Ohio's successes for this program, it could also be streamlined by removing the preliminary vetting step for projects, which creates unnecessary delays at times, and by providing permanent program guidelines for states and for our grant recipients. Regarding the Coal Regulatory Program, SMCRA is founded on the state primacy model, where states are given exclusive regulatory authority over the environmental impacts of coal mining in their jurisdiction. Maintaining the state's ability to do their job under SMCRA is critical to the success of coal mining regulation. Currently, there are several areas of concern with SMCRA. One is that OSMRE has 2 pending rulemakings that could be problematic, and 2, OSMRE has a significant backlog of state program amendments. Regarding the rulemakings, a few years ago, OSMRE updated the 10-day notice rule, which created greater cooperation between OSMRE and the states on responding to and investigating citizen complaints. This rule has worked well for us. OSMRE's current proposed change to the 10-day notice rule is a reversal of that functioning rule change. The new proposed rule reverses that cooperation and creates uncertainty and possibly federal overreach. OSMRE has also notified states that it plans to conduct rulemaking regarding dam safety. The Mine Safety Health Administration currently regulates dams on mining sites that are hazardous. In Ohio, the Department of Natural Resources manages a dam safety program at the state level for all dams after a mining permit is released. Therefore, the additional regulation proposed could be duplicate. Plan amendments. We appreciate that OSMRE is currently prioritizing and ramping up efforts to streamline the review of state program amendments. We strongly encourage OSMRE to utilize its pending resources to do that, and we need approval in order to change the state laws and rules to be in compliance. Mr. Chairman, thank you again for your opportunity to testify, and I look forward to answering questions from the committee.
Thank you, Mr. McCammon, for your testimony. Our next witness is Mr. Dustin Moran. He is the Director of the Mining and Reclamation Division of the Alabama Department of Labor, located in Montgomery, Alabama. Mr. Moran, you are now recognized for 5 minutes.
Thank you. Good morning, Chairman Stauber and Ranking Member Ocasio-Cortez. My name is Dustin Moran, and I am honored to be here as the Director of the Mining and Reclamation Division of the Alabama Department of Labor and as the current President of the National Association of Abandoned Mineland Programs. The importance of abandoned mine reclamation cannot be overstated. While the AML programs have achieved tremendous success in our 46-year history, the mantra of the programs continues to be, our work is not done. With the passage of the Infrastructure Investment and Jobs Act, Congress clearly acknowledged this reality and greatly increased the scope and scale of what AML programs can continue to accomplish for our communities. The $11.3 billion provided by the IIJA, combined with the AML Economic Revitalization Program, or AMLR, marks a transformative era for AML programs across the country. However, as we embrace this opportunity, challenges and implementation loom large. The Office of Surface Mining Reclamation and Enforcement, or OSM, has added numerous administrative complexities to IIJA and AMLR funding that hinder its efficient utilization. As the AML program grows with new funding, state staffing capacity is strained, and there is no time to waste on unnecessary administrative tasks. Distribution of additional funding to a well-established program should have been simple, fast, and efficient. It wasn't. Instead, OSM empowered itself to reinvent the AML program, and while its intentions may be good, the result has not been an overall improvement. The states fear that the new burdens imposed by OSM will have a compounding effect on program implementation with each subsequent year unless OSM changes tact. OSM's initial rollout of the IIJA AML funding took more than a year and involved minimal state program input. State program managers have practical experience and a unique perspective into accomplishing AML work. By not meaningfully collaborating with state programs, the decision makers at OSM, who have never run an AML program themselves, are making implementation policies without consulting those of us who have. Had states been better consulted, we could have avoided many of the problems we're facing. For example, OSM's requirement of separate grant applications for IIJA and AML fee grants essentially doubles the administrative efforts required, and it's not necessary. Their insistence on a comprehensive review of every state's legal authority to operate an AML program, simultaneous with our efforts to ramp up to utilize this new funding, is very ill-timed. OSM is increasingly scrutinizing state decision-making well beyond its proper oversight role and attempting to insert its own priorities into how states manage their programs. This is a crucial moment. States are striving to maximize reclamation results with temporarily limited staff capacity. To successfully implement the new funding, increased efficiency is vital, but it does not appear that OSM is recognizing this. The AMLR program faces similar difficulties. Through AMLR, states collaborate with communities and local economic development experts to develop projects geared towards economic development on reclaimed sites. OSM requires that it have the chance to vet each AMLR project during development. Again, its intentions are good, but it does not have the economic expertise to vet projects well. Certainly not better than the states and their project partners, and the result of OSM vetting has been consistent confusion and delay. For both IIJA and AMLR, OSM's interference with sound processes and state decision-making is not resulting in more impactful AML projects. It is actually reducing the beneficial impact of the AML program by hindering and delaying the completion of our work. Instead of reinventing the AML program and second-guessing the states, OSM should be focused on giving the states the support we need. For example, expanding the national training program. We have repeatedly pleaded with OSM to double the capacity of the instructor cadre with an East and West training team and to explore creative new ways to expand the capability to provide training to new employees for states, tribes, and OSM itself. Thus far, they have been slow to heed this call. I urge Congress to consider directing OSM to adjust its implementation plans and underlying priorities and to refocus on supporting the states by streamlining administration of the programs so that less time and money can be spent on administration and more on reclamation as intended. Our shared success depends on it, and together we can accomplish the mission we've been entrusted with. Thank you for your time, and I look forward to answering any questions or further discussion on this matter.
Thank you, Mr. Moran. Our next witness is Mr. Peter Morgan. He is the senior attorney for the Sierra Club Legislative Office located here in Washington, D.C. Mr. Morgan, you are now recognized for 5 minutes.
Thank you, Chairman Stauber, Ranking Member Ocasio-Cortez, for the opportunity to testify today. I'm a senior attorney with the Sierra Club based in Colorado. For more than 15 years, my work is focused on assisting local communities nationwide ensure coal mines minimize their pollution and are fully reclaimed once they stop production. The fundamental point I would like to convey with my testimony today is that OSMRE is not confronting the reality that we are on track to see a return to the conditions that led Congress to pass the Surface Mining Control and Reclamation Act, SMCRA, in 1977. That is, thousands of mines abandoned with no source of funds to complete reclamation, requiring an expansion or duplication of the taxpayer-funded AML program. Modern, abandoned, unreclaimed mine sites pose a variety of threats to communities in coal-producing states and tribal lands across the country. These sites are sources of air and water pollution and contain hazards such as exposed high walls and open mine portals. Unreclaimed mines also exacerbate flooding due to a lack of vegetation and absence of properly maintained drainage controls. Historic flooding in eastern Kentucky in July 2022 most heavily impacted communities living below unreclaimed strip mines. Congress designed SMCRA to address abandoned mines in two ways. Title IV provides funding to clean up the inventory of abandoned mines already in existence in 1977, while Title V seeks to prevent any additional mines from ever becoming abandoned in an unreclaimed state. It requires operators to post reclamation bonds and mandates that operators complete reclamation concurrent with coal removal. Both elements of Title V are currently failing. The primary problem is that OSMRE has not adjusted its approach to account for the now permanent reality of decreasing demand for coal. The U.S. Energy Information Administration recently forecast that annual coal production in the U.S. will drop almost 23% in 2024 compared with 2022. EIA predicts 2024 U.S. coal production will be 60% below the peak of coal production seen in 2008. Industry experts attribute the drop in demand for coal to market forces, primarily the cheap cost of methane gas and renewable energy. Because these market forces will persist, coal production will remain low. This decline in demand for coal has already resulted in dozens of mine operator bankruptcies, and more are coming. Nearly 70 coal mine operators filed for bankruptcy between 2012 and 2020. 4 of the largest mine operators offloaded almost $2 billion in environmental liabilities through the bankruptcy process between 2012 and 2017. Given these economic conditions, OSMRE and state mine regulators should be doing everything they can to give effect to SMCRA's core requirements, which are ensuring that bonds are adequate to cover the full cost of reclamation and requiring operators to minimize the amount of disturbed, unreclaimed area at each mine site. In fact, we're seeing the opposite. Bond amounts are set too low and in forms that virtually guarantee funds will not be available when needed. And regulators are allowing operations to sit idle, neither removing coal nor conducting reclamation. As a result, there are already hundreds of zombie mines across the country that will never return to production and where the operators lack the funds to complete reclamation. There is a narrowing window for OSMRE to take action. First, the agency must collect and make public information on mine production and reclamation status for all coal mines in order to identify the full set of these functionally abandoned zombie permits. Next, OSMRE must conduct a stress test for state bond pools and surety bond providers. OSMRE must also work with states to rigorously enforce SMCRA's contemporaneous reclamation requirements. And OSMRE must finalize the 10-day notice rule in order to afford impacted communities their full right to public participation in mine oversight. Only with rapid and decisive action by OSMRE can we avoid a new generation of dangerous, polluting, economically unproductive abandoned mine lands. Thank you.
Thank you, Mr. Morgan. Our final witness today is Mr. Kyle Wentland. He is Administrator of the Wyoming Department of Environmental Quality, Land Quality Division out of Cheyenne, Wyoming. Mr. Wentland, you are now recognized for 5 minutes.
Good morning, Mr. Chairman and Ranking Member Ocasio-Cortez and members of the House Subcommittee. My name is Kyle J. Wentland, and I am the Administrator of the Wyoming Department of Environmental Quality, Land Quality Division. My testimony today will focus on the Title V coal program. Wyoming surface coal mines are world-class operations nationally and internationally in safety, size, scale, production, reclamation, and environmental performance. And these mines contribute the greatest portion of funding to the fee-based National Coal Abandoned Mine Land Cleanup Program and black lung compensation. If I were to classify the relationship between Wyoming and OSMRE, it would fall into 3 categories. These include an agency that is paralyzed in its ability to make timely, efficient, and prioritized decisions, mistrust within the OSM organization itself, and failure to conduct meaningful engagement with its state partners. First, I will address the paralyzed aspect in the context of federal mine plan approvals. Even under the most aggressive energy transition predictions, the need for reliable and affordable Wyoming thermal coal baseload power will continue well into the 2040 to 2050 timeframe. And coal has other beneficial uses, such as coal to fiber, liquids, and rare earth mineral extraction. Carbon sequestration programs such as Carbon Safe and the Inflation Reduction Act 45Q may further extend the need to utilize Wyoming coal reserves. Deputy Director Owens testified to this committee on May 16, 2023 that the proposed fiscal year 2024 budget focuses on funding OSMRE's core mission responsibilities and supporting the highest priority efforts and activities. However, Wyoming continues to see unprecedented federal mine plan approval delays at OSMRE headquarters. As noted in my written testimony, OSMRE has changed its NEPA policy 3 times and taken 3 years to determine that the Black Butte Federal Mine Plan must now restart the NEPA process and conduct an EIS. Wyoming Governor Gordon sent a letter on April 25, 2023 to Secretary Interior Deb Haaland, and the Wyoming Congressional Delegation has reached out to OSMRE outlining the serious concern over the delays in the approval of the Black Butte Federal Mine Plan. The response has been and continues to be deafening silence from OSMRE headquarters since July of 2023. Review of the Black Butte timeline provided in my written testimony underscores that the approval process through OSMRE is broken. The process has become politicized and the NEPA process has become weaponized. The end result is costly permitting delays, increased land disturbance and mining costs, delayed reclamation, fuel supply reliability concerns for the nation's baseload power, and lost revenue to federal and state governments. Now I will address OSMRE delays in the approval of state program amendments and mistrust within OSMRE. Wyoming and other states continue to see unconscionable delays in the approval of state program amendments. A state program amendment is public noticed and receives legal review from a state attorney general and regional technical staff and solicitors prior to OSMRE headquarters' final review and approval. OSMRE's inability to approve a state rule change is best exemplified by the Wyoming Wind Turbine Blade Disposal Program Amendment. The University of Cambridge estimates that there will be 43 million tons of blades needing to be disposed of by 2050. The Wyoming Turbine Blade Program Amendment received no public comments at the state or federal level, has been endorsed by the coal and wind industries as a responsible and sustainable solution to the disposal of these blades. Approval of this program amendment is a clear win for everyone. However, OSMRE headquarters has second-guessed and continues to mistrust its regional technical staff and solicitors, and has held this program amendment for 843 days with no sign of action. The Interstate Mining Compact Commission has also engaged OSMRE on this issue. OSMRE staff agreed to provide IMCC with the agency program amendment status sheet for all states, and after 356 days, IMCC has still not received this information. It is clear that OSMRE does not trust the reviews provided by the state, its regional staff and solicitors, and Wyoming respectfully requests that OSMRE begin working cooperatively with Wyoming to address the major concerns I have highlighted in my testimony for the committee today. I would like to thank the committee for the opportunity to present this information, and I would be happy to stand for questions.
Thank you very much for your testimony, Mr. Wentland. And, I want to thank all the witnesses for their testimony. And we are going to, as I told you earlier, the votes have been called. I'm going to recess the committee. We've got 2 votes, and we'll come back as quick as we can and start questioning. So the committee stands in recess. Okay, the Energy and Minerals Resources Subcommittee will come back from recess. And before I get to my questioning, I would like to enter into the record the testimony the U.S. House of Representatives Natural Resources Subcommittee, Energy and Minerals Resources, examining the Biden administration's abandoned mine lands and active mining programs, dated November 14th, 2023, from the National Mining Association. Enter into the record without objection. So ordered. So I will start my 5 minutes of questionings. And again, thanks to all the witnesses. We really appreciate you being here. Deputy Director Owens, Mr. Wentland's testimony explained that after several years and 3 rounds of NEPA review, your office determined just last month that the mine plan amendment for the Black Butte mine could not be approved as written. Instead, the entire process must be started over, this time as an environmental impact statement. Before my question, Deputy Director Owens, how long have you been with OSM?
Representative Stauber, I've been the Deputy Director of the Office of Surface Mining Reclamation Enforcement since 2001.
Okay, so 22 years.
Yes.
Okay. Why did it take so many years and rounds of review, and not to mention official correspondence, including from the governor of the state, to get a response from your agency on this single decision reference to Black Butte mine?
Thank you for that question, Representative Chairman Stauber. As you know, the NEPA, review of making the mine plan decisions and rendering those requires a NEPA review. Those NEPA reviews require many technical reviews and analyses.
Well, Ms. Owens, with all due respect, 3 NEPA reviews, 3 years, no correspondence for the last 6 months. I find that unacceptable, because if you were in the private sector, you'd be out of business. Not responding like that. So, Mr. Wentland, in your testimony, you discussed Black Butte as an example to show that the OSMRE process has become politicized and the NEPA process weaponized. Do you still feel that is the case, or would you like to provide your perspective on Ms. Owens' answer on the mine plan amendment?
Thank you for that question, Mr. Chairman, and I would like to provide a perspective here. First off, we have to go back that the Bureau of Land Management is the coal leasing agency, and in order to lease coal, you have to get BLM Resource Management Plan goes through, discloses the coal that's available, and then when the coal is actually leased, it conducts another NEPA review, and they're in charge of leasing and selling the coal and getting it to the public. OSM's review is about the mine plan. It's about the impacts within the mine permit boundary. And OSM has expanded that review now to go on into even questioning BLM's own NEPA reviews between the agencies. And I believe that OSM and their NEPA reviews needs to be brought back to within their lane. They are outside of their lane of review, and that is what is adding time and stress to the system.
Ms. Owens, many states have expressed concerns about the so-called recommendations your agency created for applications for the $11.3 billion in IIJA funding for AML cleanup. These extra considerations have taken time away from state regulators doing their job and take resources away from filling the hole in the ground. Why has your agency seen fit to place new considerations on IIJ funding for AML cleanup when the program already has clearly defined goals and considerations in statute, and in spite of the many concerns expressed by impacted states?
Thank you, Chairman Stauber. As you know, the $11.3 billion that the bill provided to the abandoned mine land program is a once-in-a-generation exponential increase of resources to address the problems associated with abandoned mine land programs. When the bill, and a bipartisan infrastructure law bill, when the bill was passed 2 years ago, one of the first things we did was to determine that we would provide guidance to the states in terms of what new requirements or what additional requirements would be associated with their use and receipt of those funds. We could have taken a regulatory route, and that would have been a protracted action for us. It would have.
Ms. Owens, just because my time's limited, and I do appreciate your response, not that I agree with it, but I want to ask Mr. McCammett, you've heard Mrs. Owens' response now. In your experience with OSM's treatment of the active coal mining program in your states, does it seem to be a fair assessment? And I'll ask you, Mr. McCammett, and then Mr. Moran and Mr. Wentland for quick answers to that.
Thank you, Mr. Chairman. I would say that our state effectively implements the coal program according to the SMCRE regulations, and we follow all the provisions of that rule, and I would say that we are effective regulators in our state.
Right. Mr. Moran?
I think we could use increased collaboration with the states and OSM, and not just in word only, but actual meaningful collaboration where our input is heard and then seen, and the implementation guidance documents were provided.
Mr. Morgan, or correction, Mr. Wentland?
Mr. Chairman, you know, SMCRE says that the requirements are as effective as, not as stringent as, and it also confers very specific primacy rights to the states. And because of that, the states are the principal regulator. Wyoming has been that regulator for 43 years of the 47 years of the program. We are very confident in Wyoming's regulatory program, and OSM's role should be the oversight role that SMCRE envisioned.
And assisting in a positive way. My time is up, and the next individual, Representative Kamlager Dove, you're up for 5 minutes.
Thank you, Mr. Chair, and thank you, Ranking Member. Ms. Owens, we've heard several complaints so far from the other side of the aisle about how bureaucracy is holding up getting money out to the states and tribes that Congress authorized in the Infrastructure Investment and Jobs Act. I will remind my colleagues that cutting agency funding as proposed in their appropriation legislation won't help. We're talking about more than $11 billion of new federal funding over 15 years. It is an enormous ramp up of these mine cleanup programs, and I expect it will take time. And I also believe that we want to see it done right. So how are you assisting state programs in ramping up their capacity? And what would the Republican proposed cuts do to that assistance?
Thank you for your question, Representative. I'm not aware of the cuts to the budget, but among the things that we are doing to assist the states, you know, we have given them the FY22 bill grants. We got those out. We've already begun to process and got 7 FY23 grants out. We have improved our training programs. We've established at least 4 new training programs that are focused on the new requirements of the bill requirements, as well as providing training to new employees, because both OSMRE and the states are bringing in new employees so that we can administer and get these grants out and get the funds out and get them out to the states so they can actually begin to get those projects on the ground and working. We also are putting additional information into our e-AMLIS system, identifying and working with them on developing metrics so that we indeed will be able to measure the success of this program and do it responsibly. As you point out, this is so much more funding than we've had. And so we want to make sure that it is maximized. We only have 15 years, so this is not just a program that's going to go on forever. Within the 15 years, we need to get it right. And our approach to this was, let's get it right from the beginning, which is why we took time to get that bill guidance out in the first place. You know, we couldn't just put billions of dollars out there. I mean, some of these states have 5-10 times money under the bill grants than they have under their AML fee-based grants. And so we wanted to provide some additional guidance for them to make sure that it was going to be consistently applied across the program and that it would result in success and achieve the goals that the bill funds were provided in order to achieve.
Thank you. And Mr. Morgan, I have some questions for you. I have limited time, so hopefully we can get through them quickly. You've been raising concerns about this bankruptcy and abandonment issue for a while. So why didn't we see these systemic bonding failures earlier? And did coal companies know that their bonds would not hold up?
Thank you for the question, Representative. I think the difficulty that your question alludes to is that there is a significant disjunction between what we're seeing on paper in terms of what regulators are reporting in terms of the status of mines, and then the actual lived experience of communities near these mines. On paper, mines appear to be active, but in reality, in many cases, they have been long abandoned, workers laid off, equipment removed, left unreclaimed, and that has prevented us from getting an accurate assessment of the actual state of the coal mining industry.
And so you referenced the problem of functionally abandoned permits. What exactly do you mean by that, and why is it a problem?
So these are those permits I was just describing, where on paper they appear to be active coal mines, but in practice they have been abandoned and often left in an unreclaimed state. And because regulators are aware that the sites are underbonded, the regulators are hesitant to take the sort of enforcement actions that are required, because if they recognize the reality that these are abandoned mines and they revoked the permits and forfeited the bonds, there isn't the money available to complete the reclamation, meaning either taxpayers are responsible for those costs or the communities are left living next to dangerous unreclaimed mine sites.
Thank you. You know, my time is up. I have additional questions that I will refer to the committee so that we can get answers later on from you. Thank you so much, and I yield back.
Chair now recognizes the gentleman from Wisconsin, Mr. Tiffany.
Thank you, Mr. Chairman. Mr. Morgan, do you believe coal use should be ended in the United States of America?
I believe the market is speaking to that, and coal is no longer cost competitive.
Do you view Boiler Act, I'm sure you're familiar with that regulation from about a decade ago, do you view that as a market force?
I believe that there are a lot of headwinds against the coal industry, that even if you removed one or two, the overwhelming dynamic is going to be continued decline.
Is Boiler Mact a market force?
I believe it is internalizing an externality and having the industry bear the cost of its pollution. So yes.
Appreciate your answer. Boiler Mact is a federal regulation. Let me give you an example of its failure of what you call market forces. I have a mill in my district that installed a smokestack. They had to put up a higher stack. And the company invested north of $10 million in that. You know how much it reduced in emissions?
I do not.
None. Zero. It didn't reduce emissions at all. And this company had to spend $10 million of precious capital. That is not a market force. I can guarantee you that much. Mr. McCammon, was the 10-day rule working for you guys in Ohio?
Yes.
Mr. Moran, was it working in Alabama?
I'm here solely for Title IV. I don't do the regulatory side of things in my
And
state.
Mr. Wentland?
Absolutely, yes. The 2020 rule was a good rule.
Ms. Owens, are you rewriting that rule, the 10-day rule?
Yes, Representative, we are rewriting the rule.
What is the deficiency? Why are you rewriting that rule within your agency?
Well, there were several, when we reviewed the rule, there were several aspects of it that we determined we wanted to revisit. Among them were what we felt were unnecessary burdens that were placed on citizens who wanted to either file a complaint, a citizen's complaint, which the SMACRA gives them the right to do, and we wanted to make sure that they were having that opportunity without undue burdens in doing that.
Thank you. Would you say your bureau has issues with bandwidth and staffing at times that causes delays? I mean, we've heard some about that.
I'm sorry, I didn't get the first part of your question.
Does your bureau have issues with staffing at times and just bandwidth to be able to get these processes done that causes delays?
Well, yes, we do have staffing issues, as many agencies do.
So why would you pull this back from the states? Why would you pull this back with the 10-day rule that is working, as these gentlemen to your left have said? Why would you pull that back if you've got staffing issues, if you have delays that are happening as a result of whether, call it bandwidth or staffing delays?
Well, thank you for your question, Representative. We have resources that review our regulations, and one of the things that we did at the beginning of this administration was to review regulations to determine if there were aspects of those regs that required our taking another look at them, and that is exactly what happened with the 10-day notice rule. And so we do have adequate staff that took a look at that rule and we have now proposed some amendments to the 10-day
Mr.
notice
McCammon,
rule.
do you expect emissions in your state to be reduced by the federal government taking additional authority away from you by amending or changing the 10-day notice rule?
No, we do not. I think we would expect that we would spend more time and less cooperation with OSM in investigating legitimate complaints with the reversal in the rule.
So as a result of delays, we actually could see more emissions by projects not getting done. Would that be correct?
Yeah, spending more time in responding to complaints that we have already responded to previously or have data or information on. So yes, it could cause further delays.
Ms. Owens, have you been instructed to stop or slow roll applications for coal projects?
No, sir, I have not.
Have you had anyone from the White House contact you and send a clear message that they want coal stopped?
Absolutely not.
Mr. Chairman, I yield back.
Gentleman yields back. The chair recognizes the ranking member, Ms. Ocasio-Cortez, for 5 minutes.
Thank you, Mr. Chair. Coal mining has, and much of the abandonment of these mines have left a toxic legacy of contaminated soil, polluted waters, and public health disasters across the country. And while I'm proud of the more than $11 billion passed in the Infrastructure Investment and Jobs Act to help states and tribes clean up abandoned coal mines, I do think it's important to reiterate that these are not costs that the American public should have to pay. This is a responsibility of mines and private companies that inflict this damage. And it's yet another example of the ways in which these large companies often privatize benefits and profits and socialize the costs and harm. And for the public to have to pick up the tab on this demonstrates the failure for us to properly assign and enforce that responsibility, that financial responsibility, where it belongs. The mines we're cleaning up with the IIJA funds were abandoned before SMCRA was enacted, the law to ensure coal companies clean up after themselves. Mr. Morgan, in just a couple of sentences, to make sure that we can refresh to folks that are following along at home, what is SMCRA in the most simple terms possible, and how does it apply differently to mines that were abandoned before and after it was enacted?
Thank you, Ranking Member. So SMCRA was passed by Congress in 1977 to address the then-present crisis of thousands of abandoned mines across the country, and it sought to address that in two ways. One was through creating Title IV, which is a fund used to clean up the existing inventory of abandoned mine lands present at that time. But Congress also wanted to avoid a recurrence of those abandoned mines. So SMCRA also includes Title V, which primarily consists of two components. One is a reclamation requirement that companies conduct reclamation contemporaneously with coal removal. And then the second part is a bonding requirement, which ensures that if a company does go out of business, there are adequate funds to the regulator to complete the mine cleanup.
Thank you, Mr. Morgan. And yet, as we heard earlier in your testimony today, many modern coal mines are going unreclaimed. And right now, we are at risk of yet another wave of abandoned mines, another wave of destroyed land, another wave of environmental and health outcomes. And Mr. Morgan, if SMCRA was meant to ensure that modern reclamation would be fully paid for by the industry, these are the folks that are supposed to be paying for it, then how did we get to this point of these abandoned modern mines? And how are companies actually evading their healthcare, pension, and reclamation responsibilities?
So there's three primary problems with the implementation of SMCRA that's leading to these problems. So first, the contemporaneous reclamation requirements are not being enforced, which allows mine operators to accumulate significant acreages of disturbed land. And then when those companies run into financial difficulties, that increases the reclamation burden passed on to taxpayers. The second part is when regulators set bond amounts, they fail to require adequate bonding. So in the recent bankruptcy of Black Jewel, the Kentucky regulator in the bankruptcy proceedings filed documents saying that they looked at 20% of the company's permits. So that was 33 permits. And they found a reclamation bonding shortfall on those 33 permits of $28 million. And then the third problem is the form of bonds that are provided are ones that do not ensure that the money will be there. So many of the eastern states rely on bond pools, which don't have adequate funding and are at great risk of being overwhelmed by the bankruptcy of even a single operator. Even surety bonds, which are supposed to be the most secure, run into difficulties because a very small number of surety bond providers have issued the overwhelming number of those bonds, meaning that if they fail, which they could do if even one big mine operator goes out of business, it would wipe out that surety and all of the bonds they've provided.
Thank you very much, and I yield back to the chair.
Gentlelady yields back. The chair recognizes the gentlelady from Wyoming, Ms. Hageman, for 5 minutes.
Thank you, Mr. Chairman, and a special thanks to each of the witnesses for being here today. It's no secret that over the past few years, we have experienced substantial delays, unclear and oftentimes conflicting guidance, and overbearing requirements for coal mining states and communities because of this administration's war on fossil fuels. While the BLM has promulgated rule after rule to make it more difficult for energy-producing states to produce affordable, reliable energy, such as coal, the Office of Surface Mining and Reclamation Enforcement has now decided to prioritize the cleanup of abandoned mine lands based off of certain socioeconomic factors. These new priorities ultimately make it more difficult for coal communities in my home state to secure federal funding. Many coal communities are not deemed as so-called environmental justice communities, whatever that means, according to CEQ, and will therefore struggle to meet the outlined requirements when it comes to recovering lands impacted by abandoned mines. Ms. Owens, why is the OSM making it more difficult for communities in my home state of Wyoming to secure funding for AML remediation?
Thank you for the question, Representative Hageman. I don't believe that the Office of Surface Mining is making it more difficult for your state to receive funding.
Well, but you're doing the funding based upon these social justice, certain environmental justice requirements that have essentially excluded the state of Wyoming. Are you aware of that?
I am aware of the requirements. I also would like to point out that those, along with several other of the provisions that are contained in our bill guidance, we are encouraging states to adhere to certain, to take certain
Environmental
actions.
justice requirements?
Yes.
Okay.
We are encouraging them to do so.
Okay. During the previous administration, OSM partnered with BLM and other sister agencies to perform dual NEPA analysis, share data, and better improve the process of getting federal coal permits out the door, which should actually be the mission of your agency. But since 2021, this effort, we are told, is stalled, and what began as an attempt to speed up permitting is now the complete opposite. State agencies and operators alike have communicated to me that OSM is now just a roadblock that single-handedly delays coal mining and thwarts the permitting process. What is OSM doing to become more than just a regulatory roadblock for the coal industry?
Thank you for your question, Representative. What we're doing is we are implementing the requirements of NEPA, which is a requirement for all federal...
NEPA as amended? NEPA as amended earlier this year?
NEPA, whatever the law is on the books, at the time that we take our actions, we implement the law on the books.
Okay, but the NEPA was amended earlier this year. It's on the books now. So are
Yes.
you taking the changes in NEPA, the amendments to NEPA, into consideration when reviewing these permits?
If they have been promulgated, those regulations have been promulgated, yes, we are.
Well, the statute has been promulgated. The
Yes.
amendments have gone into effect. Are you
all-
not aware of that?
Yes, ma'am, I am.
Okay.
And we are implementing NEPA law and regulations.
As it
and
exists
guidance.
now?
Yes.
Program amendments are absolutely vital to the states and often are a result of state legislators passing bills to help their state coal programs. OSM, however, has failed to process these permits in a timely manner, resulting in a backlog of state program amendments that go all the way back to 2006. Why doesn't OSM work through state program amendments in a timely manner?
Well, as you may be aware, Representative, the state program amendments often involve technical reviews. We have to consult with technical, legal reviews, analyses. We consult with any other federal agency.
So you're taking are you saying it takes up to a decade to process these programs?
Well, I think you may be talking about a rare situation. I'm not aware of any case that's been any state program amendment that has not been processed since 2006.
Okay, well,
But-
that has been
but I
that
will-
has been the circumstance that we have experienced. So I would request that we expedite those programs so that they can go forward.
Well, as a matter of fact, and I thank you for that suggestion, but as a matter of fact, I have directed the staff to take a look at ways that we could expedite the review of state program amendments, and also to identify processes that would help us streamline and also address the backlog. We are very much aware of that, and we are taking actions so that we can address it.
Okay, I appreciate that, and I'm out of time, so I yield back.
Gentlelady yields back. The chair recognizes the gentleman from Montana, Mr. Rosendale, for 5 minutes.
Thank you very much, Mr. Chair, and Ranking Member Ocasio-Cortez for holding this hearing today. Montana is home to 3 of the top 20 most productive coal mines in America. So this issue is critical to my constituents. Furthermore, Montana boasts the largest estimated recoverable coal reserves nationwide, constituting approximately 30% of the total U.S. reserves. Despite these significant reserves, Montana has experienced a steady decline in coal production since the Obama administration, with a drop of nearly 900,000 tons in the past year alone. Now, while my colleagues across the aisle would like to attribute this to a lack of demand, we just know that that is not the case. The case is that this supply, this production has been reduced simply because of the radical environmentalists' ability to keep us from mining those very critical energy reserves. Mining stands as the lifeblood of Montana, woven into the fabric of our state's culture and tradition. Regrettably, this industry has been under consistent scrutiny from the Biden administration and the climate activists. The 3 mines that are located that I mentioned face constant delays by the Biden administration in completing environmental impact studies, which are essential for initiating new mining projects. The Spring Creek mine is anticipated to deplete permitted coal in May of 2024, with an expected EIS completion date of November of 2024. The Bull Mountain mine is projected to exhaust permitted coal in September 2024, with an expected EIS completion date of June 25. The Rosebud mine in Colstrip, Montana is set to deplete permitted coal in April 2024, with an expected EIS completion date of March of 2025. Notice the pattern here. The EIS dates are projected to be beyond the date when they're going to deplete their coal reserves that they have available to them at this moment. Yet, there's incredible coal deposits there that are still available to be mined. Each of these mines individually provides crucial jobs and energy to my constituents and to the rest of America. The potential loss of all 3 would be disastrous for Montana, leading to energy insecurity and leaving many residents unemployed with no immediate prospects. This goes to show how urgently our country needs permitting reform. Despite being one of the few issues that has bipartisan support, the Biden administration has exhibited extreme hesitation in pursuing the NEPA reforms. These reforms are not only necessary, but need to be implemented promptly to ensure our nation can efficiently utilize its natural energy resources, maintaining energy independence amidst a volatile global landscape. It's unacceptable that in less than a year, these mines may no longer produce permitted coal, forcing Montanans to rely on foreign adversaries to meet their energy needs. This process must be streamlined urgently, or our state's and our nation's energy security will face peril. I hope the testimony and questioning today will shed light on these critical issues, fostering bipartisan solutions that will secure and maintain our country's independence in the energy sector for the coming decades. Ms. Owens, could you elaborate on the reasons behind the continued delay in issuing the EIS reports for these mining projects?
Thank you for your question, Representative. The requirement for the review of the mine plans that you mentioned require us to apply NEPA. It is a requirement. Recently, and we have had ongoing court decisions that have had a direct impact and bearing on our NEPA review of these various mine plans. And in fact, they have, as a result of these court decisions, we have had to reassess and make changes in our review, in our NEPA review, based on the legal requirements. We have to make sure that we adhere to those decisions. We want to make sure that when we render a decision, that it will pass judicial.
Okay, so I didn't hear the
scrutiny.
reasons, Ms. Owens, and I hate to cut you off, but I have a very limited amount of time here. I need reasons, okay? And what I've seen
reasons-
typically in the past is somebody didn't cross a T or dot an I properly, and you use the system in order to delay the ability to approve this.
To the contrary.
Mr. Chair, I see that my time has expired. I'm going to have to yield back.
Thank you very much. The gentleman from Georgia, Mr. Collins, you're up for 5 minutes.
Thank you, Mr. Chair and Ranking Member for having this meeting. Folks, as someone who doesn't have a coal mine but uses coal, I guess you could say I'm a consumer in Georgia. About 20 miles from my house is Plant Share, which has 4 units that produce electricity using coal. And out of the 4 units, 1 is shut down. And in a recent visit while I was there, I asked them why, and it just so happens that, just as a side note, this was the most profitable way of producing electricity for this other state that was selling it to their consumers, but they shut it down due to a backlash or being forced to, which really didn't make any sense when they were sitting there showing us the stacks and how clean the air that comes out of these stacks are now and how clean the coal is being burned. So it makes me wonder exactly what is the problem here and what's going on. And I kind of want to bounce off of what my colleague, Mr. Rosendale, was talking about. He's talking about active mines, and I want to look at active mines and some of the abandoned mines as well. All that to be said, I've got just a few questions real quick. Mr. Moran, is that how you pronounce your name? Okay. All right. Well, you're an Alabama boy, but you got a different name. You know, we got short names. And
Yeah, Moran will be fine.
Moran, okay. To your knowledge, does anyone in the Office of Surface Management Policymaking Group in its headquarters office, do they have any experience in operating an abandoned mines land management program?
Not to my knowledge, no, sir.
And what effect may that lack of technical expertise have?
It shows in their guidance and their implementation policies, which is why I requested not only collaboration in word, but meaningful collaboration with state program managers. We do possess unique knowledge of what it takes to get these projects on the ground and operational, reclamation projects. And so I feel like they deprived themselves by not listening to our input and incorporating it into their guidance.
Thank you, I appreciate that. Ms. Owens, I've heard that the substantial increase in the abandoned mine land funding from the IIJA that was mentioned earlier is causing some states to divert their limited state resources from their active mining programs to their AML programs. This is being done, I think, in an attempt to make the most of those valuable AML grants. And I think this is where Mr. Rosendale and I were I was listening for his answer. So what is the Office of Surface Mining Reclamation Enforcement doing to ensure that active mining programs don't suffer because of the rush to spend that money on those AML programs?
Thank you for that question, Representative. If the states are organized as the federal program, there are 2 programs, Title V, which is the AML, and Title IV, which is the AML, and Title V, which is the active mining. We have staff. Each of those programs has staff that are familiar with and operate those programs. I'm not aware that states would be pulling their Title V staff to do the Title IV, particularly since with this bill money, one of the first things that we at OSMRE did was to identify the positions that we would need to effectively implement the bill the bill program and get those grants out to the states so that they would have resources. They'd be able to bring on additional staff and resources. And I know it's been a challenge. It's been a challenge at the federal level. It's been a challenge at the state level because we're all looking for the same staffing and
So you would agree
resources.
that they are diverting staff to go after the abandoned
I'm
mines
not
instead of?
aware, I'm not aware that they would be diverting.
But you are aware
Title
that these
Vs.
active mines are having problems. I mean, Mr. Rosendale just alluded to that,
I'm sorry, that they,
that the active mines are having a problem getting their projects either reapproved or approved.
well, we.
And would you not agree
the-
that the people are using their staff to go after the IIJA money instead of helping these active mines?
I am not aware of that.
Even
fact,
though
sir.
that Mr. Rosendale just gave you a prime example of
Well,
coal mines
he-
in his
He
district.
stated, he asked me if that were happening. It's
Well,
not
and he
happening
provided an
in our
example.
federal program.
All right. Is it true that the backlog of pending state plan amendments includes some revisions that are going all the way back to 2009?
I am aware of one situation in which that is the case.
So you wouldn't say there's a backlog?
I did say there is a backlog. In fact, we are, as we speak, the staff is looking at ways to improve our procedures so that we can streamline that process.
All right.
And so that we can get rid of that backlog.
Thank you. I'm sorry, I went over. I yield back. Sorry about that.
Thank you very much. The next one up is the Chair of the Full Committee, Mr. Westerman. You're up for 5 minutes.
Thank you, Mr. Stauber, and thank you to the witnesses. Mr. Moore, you've testified that OSM's collaboration with states and tribes is just in name only. Has it always been that way?
Thank you for the question,
Said
Representative.
I'm sorry. Moran, not Morgan.
No, it hasn't always been that way, but we did identify and meet with our counterparts at OSM in January of this year that over the last several years, there has been a deterioration in the relationship, and a lot of that deterioration you can trace back to states trying to provide input into ways to shape the implementation of this program and the OSMRE program more efficiently, and that input seems to go by the wayside when we get the guidance, the official guidance released from OSM.
So what recommendations would you have to improve the working relationship between OSM?
We're trying work groups, and I think we've had some success with some of the state OSM work groups, but continuing that discussion and getting states involved earlier in the process. Oftentimes when we get a guidance or some new information from OSM, it's released to us at the same time that it's released to the public. There have been times where non-governmental organizations identify the release of a new guidance document before it's been sent directly to the states. So giving
So
states...
somebody's working in collaboration with the NGOs is what?
They seem to peruse the website more frequently than somebody who's managing a state program,
we
so
think
we
some of
do
them
learn
may
about
be-
it that way.
We think some of them may be actually running the programs in the federal agencies. Mr. McCamey, your testimony mentions that Ohio has 6 state program amendments that are still pending approval dating back to 2015. Mr. Warren and Mr. Wentland said there's like 55 total plan revisions waiting in DC. What have you heard from OSM about why these approvals are taking so long, and what is the consequence of not allowing these state programs changes to occur?
Sure. Thank you for that question. The impact to us of not having those approved is that if we have a new program amendment that we need to issue, then it just adds to that backlog, right? And these changes need to be made by state laws and state rules to make sure that we're meeting the intent of SMACRA. So there needs to be a process that those move quickly and are approved, and an engagement process. And most of those, as we get annual updates on those, are just in some review step.
And Mr. Wentland, I know that you would think reclaiming abandoned mines would be a bipartisan issue, but and speaking of delayed state program amendments, you provided an example in your testimony of how the state of Wyoming was trying to allow retired wind turbines to be used to backfill mine land sites. and you did this back in 2020, but the program amendment has been under review at OSM for 843 days. I was out in the state of Washington a year or so ago, and the DOE laboratory there, they said that a fact that a lot of people don't realize about windmills is that 25 years from now, there's not a single windmill in operation that will be in operation. So there's going to be a huge need for places to landfill all these windmill blades. Has OSM given you any explanation of what's taking so long?
Mr. Chairman, Representative Westerman, no, they have not. We have been sitting and waiting, and this is a good win for everybody. You know, the coal industry, the wind industry, all supported the state initiative here. And it also provides a revenue stream at mine closure, which accelerates reclamation. So we just cannot see what the holdup with this program amendment is.
So, would you like to answer that question? What's the holdup?
Thank you for your question. Actually, the issue of the placement of those blades is one of the aspects of that proposal that requires legal review. And we have been and continue to make sure that we get this right. Because if SMACRA doesn't allow those wind blades to be placed on those sites, we cannot approve it. And so we are making sure that we are, our approval or review
I'm sure
of
that
this.
that clarified it for everybody. In my last few seconds here, I'm doing a little tally of agencies that are following the law and breaking the law, and Ms. Hageman mentioned this. I know you've talked about going through the NEPA process. You can either just say we're breaking the law, or you can tell me how you're implementing the FRA limits on NEPA of either 1 year for an EA or 2 years for an ESA. The floor is yours.
Well, I wouldn't say we're breaking the law.
Are you implementing the law?
NEPA, yes, we are.
Are you implementing
law.
the 1 year and 2 year requirements that was passed
Well, we are-
bipartisan in the House, bipartisan in the Senate, and signed by President Biden?
We are assessing our timetables.
Not are you assessing, are you following the law?
We are attempting to follow the law.
Not attempting to follow the law, are you following the law?
We are doing our best to come within the timelines that have
Well,
been established.
can you provide the
in law.
committee with a timeline of specific projects that you will have completed by the 1 year time frame and the 2 year time frame?
Can I provide you with a list?
Yes,
I can provide you with a list.
with specifically projects when they will be completed in 1 year if they're an EA, or in 2 years maximum if they're an ESA.
I understood your question, and I will.
When will you have that list?
I will have to go back and see when we could make it available.
Let's
but
do
we
it in
will.
about 2 weeks. I yield back.
Thank you very much. Chairman Westerman, I think that your questioning is very relevant because they're not following the law. When Congress writes a law and it becomes, writes legislation, becomes a law, it's not a recommendation or a feeling to follow the law. You must follow the law. EA, shot clock 1 year, EIS, shot clock 2 years. That's the bipartisan piece of legislation that was signed into law by the president. And it's simply unacceptable that agencies within our federal government are not even following the laws that we wrote and that they must follow. So it's unacceptable. So I thank the witnesses for the valuable testimony, the members for the questions. The members of the subcommittee may have some additional questions for the witnesses, and we will ask you to respond to these in writing. Under Committee Rule 3, members of the committee must submit questions to the committee clerk by 5 p.m. on Friday, November 17th. The hearing record will be held open for 10 business days for these responses. If there is no further business, without objection, the committee stands adjourned.